Hey, good afternoon, all. Thank you guys for joining us for the South Carolina eviction update. I'm Michelle Lorick. I'm going to be one of your moderators along with Thomas Howard of Brownlee, Whitlow, and Pratt. We're also going to be joined with Chris Loebsack and Will Brownlee from Loebsack and Brownlee. So this is our first time doing this, so there might be some glitches. As far as that goes, please bear with us if it happens. We are recording this, so a link of this will be sent out to all participants later in an email. The Upper State Apartment Association, as well as Loebsack and Brownlee, are going to be posting this on their respective YouTube sites. So you can always access this again through that. We do have a Q&A. We're going to be doing that at the end of this. So if you go down below, you'll see where there's a Q&A section. Please do that rather than the chat. As moderators at the end of this presentation, Thomas and I will go back and forth choosing questions to ask Chris and Will based off of what is submitted with the Q&A, not with chat, with Q&A. Please remember to do that.
It helps us to track it. Yeah, it makes it easier for us to track what's been answered and what hasn't. I just noticed there's a little feature on there for us to do that.
Perfect. Also, links to the documents that we're going to be going over and the websites will be posted in the chat after the Q&A starts. So I guess we will start off. Who's going first, Chris or Will?
Yep. I'll jump in and then we'll get to some real details. So thanks everybody. Some of you may have been on some of these earlier calls that we've done for the North Carolina side of things, but if everyone in here hasn't heard any of these updates yet, we're going to do our best to try and give you the same kind of information that we've been giving out for the last week or so to the North Carolina clientele. And I know a number of you that are in here probably have properties in both states. So we're going to stick to South Carolina stuff today, but there is a section that will come second that I'll be talking about where there's a couple of federal updates that apply across the board to certain categories of property management professionals. But the beginning, the idea here is to take you through sort of a chronology of what's happened in South Carolina State Court over the last week or so in regards to actions by the Supreme Court that have affected our clients and the practice of evictions. There's been a number of documents put out by the court. Will's going to go through those with you. There's 3 of them that we've got for you today. And he'll go through those with you and sort of walk you through each one, what it says, explain what that means, and then talk about some of the cause and effect things that go along with it. What, now that it's in place, what are we doing about it? How are we handling it? What can you expect? And things of that nature. And then we'll come back to me and I'll give you a little brief overview on the 2 key federal releases that have come out, one last week and one this week, that deal with federally mandated suspensions of evictions for certain categories of properties or certain categories of owners. So without much further ado, we will do our best to give you all the questions that we can get our hands on between now and 2 o'clock. So once we get done talking about the documents, we will let Thomas and Michelle walk us through some of the Q&A and try and get everyone as up to date as we can. As I do almost every time I give a legal seminar, bear with us because neither Will nor Thomas nor I are counsel for everybody who's on this call. And so we can't address every single situation as if we are your lawyer. But so if you ask a particular question that sounds something like, at my property, we have this one person who wants to do this, what should I do? We're not going to be able to help you with that today, but you can email Thomas later and he certainly can. But we'll do our best to cover all the general topics we can and give you as much general guidance as we understand it today. So without further ado, Mr. Will Brownlee, who I'm sure all of you all know and love and miss. Here you go. Take it away, Will.
Thanks, Chris. And before I go on, I'm sure Chris and I and Thomas, the 3 of us especially, want to thank the South Carolina Apartment Association members who have made this happen, the Upper State and Charleston Apartment Association, Greater Columbia. And thanks to all of you who are joining on the call as well. This is really super cool, great resource, and so pleased to be part of this and to have you set this up. As Chris alluded to, things have been happening fast and furious in the court system, just like they have everywhere else. I mean, the pace of changes happens by the hour, sometimes, if we're lucky, by the day. And in the court system, just to give you a brief overview of how we got to where we are, things started changing, of course, like they did everywhere else, roughly about 10 days ago. There started to become a flurry from the Supreme Court of various orders, directives, memoranda to the circuit courts, to the, and it culminated in one specifically to the courts that affect you and us the most, which are the summary courts / magistrate courts. Michael, if you want to throw up that first order from the 16th. In that particular order, in the highlighted language, it appeared to be pretty much business as usual. It was subject to some restrictions, some delays in the hearings of evictions, which is the thing that's near and dear to your heart on this particular webcam. But at the same time, it made clear that the magistrate courts were to stay open for business and accept all new filings. So as you needed to file, business as usual, send it in, or file on your own or file through a law firm like ours, and they would still accept it. So, it was no drama, and it was actually a comforting order that came on the 16th. However, we, as a firm, started noticing some immediate resistance from the magistrate courts around the state. Some did want to file, some didn't, and we kept directing them back to the Supreme Court's order saying, well, you've been ordered to continue to accept filings, and that's what we informed all of our clients. That then progressed to the next order that came down the very next day on the 17th, which, Michael, if you can throw that up on the screen as well. It was a short and sweet order, but it was very powerful. It didn't direct the courts to shut down processing or intake of new evictions, but it did do one important thing, which was to continue all pending cases that had already been filed before the court. They couldn't be heard until a date no earlier than May 1st. That means wherever you were in line, wherever your case was in processing, it couldn't even be heard in the courts until starting May 1st. We're not to May 1st yet, we're not even close, but the thinking at the time was this was going to start developing a moving platform, like an escalator. Based on when you jumped on is when you would be heard sometime after May 1st, but still the doors were still open at the courts for filing altogether. However, our firm, maybe some of you individually, noticed, again, even stronger pushback from your local magistrate courts. Some were filing, some were not, some were closing the doors entirely, even though there was a standing order from the 16th saying keep accepting new cases. And then we fast forward to the very last order, and Michael, if you want to put up the third order, and this is the last order that affects evictions. The last word is one that was entered late on the 18th. We all saw it early in the morning on the 19th of March, and it's much broader. This one, and I'll just read it. You can read it on the screen. It is ordered that all evictions currently ordered and scheduled statewide shall be rescheduled for a date not earlier than May 1st. That's just a restatement from the second order. But then it went further. It said, furthermore, the court shall not accept applications for ejectment, schedule hearings, issue writs, or warrants of ejectment, or proceed in any manner regarding evictions until directed by subsequent order of the Chief Justice. So I'll stop there. So what the court essentially did, they didn't use the word stay, which is a legal term of art of meaning a freeze in place, frozen in time. Any of those descriptions is correct. It put the freeze on all pending evictions. And this may be the source of a lot of your questions later on, but what about evictions that you've already had heard? It's already gone through the process. You were in the midst of having a writ/warrant executed by your local constable or sheriff. This order put a freeze on everything. So in terms of filings, cannot do it until the Chief Justice now orders otherwise. If you want to proceed with a writ that was pending that the constable may have had in their hands or had already posted a set out, that's frozen as well. And of course, basically anything having to do with evictions per this order are now essentially frozen for the most part. Now there is an exception in the very next line that some of you maybe have already read ahead. It says, however, case-by-case exceptions for evictions may be made for matters that involve, quote, essential services and or harm to person or property. And I'll try to break that down as best I can. Essential services is referring to a defined term in South Carolina's Code of Laws. Services that as landlords, you're expected to provide your residents. Basic services such as utilities that came with the, air conditioning, plumbing, basic services that serve the property that is normally your duty as a landlord to maintain anyway. If there is a dispute or an interference or damage to those essential services, that could open the door to a filed eviction. That also moves on to the next, which is harm to person or property. That also is supported by a separate set of state codes where if they are causing harm to property, damage to property, that rises to the level of, intentional damage or even highly negligent damage that harms the property, diminishes the value. That could also qualify. It could also include crime, of course, because you're talking harm to a person. You're talking physical harm, crime. It could be assault, battery, domestic violence even. The court opened the door for that. However, there's a key word, and a lot of people blow past that word, and the word in that last sentence is the word may be made. When the Chief Justice issued this order, he said that case-by-case exceptions may be made for matters involving essential services and or harm to person or property. What he's saying is, I'm not going to tell you what to do. I'm going to leave it to the individual jurisdictions to decide for themselves. Of course, it's just a colloquial example, but in our office, we've had at least one example come in of a crime on the property that we felt fell into possible harm to property or person. But when it went before the local magistrate's court, they said, nope, not taking any. We don't care what the subject matter is. We're refusing to take the case. So this is a fair warning to all of you. Don't read too much into this order because the court did not order the courts to take criminal matters, harm to person, property / essential services. It made it optional. And as the stay and place orders around the state start exploding more and more, it's easy to see how more and more courts, maybe even most of them, will say, we're not taking your eviction case, even though it falls under the exception, because it's our discretion if we want to take it or not. And so the follow-up question, and this is one we've all been asking ourselves, is, how much longer can this go on? How much longer can the Chief Justice order? Well, as you see in these orders, he references a citation to the South Carolina Constitution called Article 5, Section 4. And not to get too deep in the weeds, but all that constitutional provision does is it appoints one person as the administrative officer controlling all the courts in South Carolina, and that person is the Chief Justice. So when he cites that constitutional provision, he in theory has the right to open the court, shut the courts, define what cases come before it. Some of you may have also asked this question too, and it's probably too big of an issue for us to address on this webinar today, but I know we've all been asking ourselves this question, which is, how can he do this? How can he just slam the door shut to the court system to not even accept new filings? And that's probably another issue for another day. I think there are constitutional issues involved in closing the doors to the courthouse. It invokes part of our US Constitution, our right to petition, our right to file a lawsuit. But honestly, I think we're one of many different parts of our government right now where we're all wondering, is this allowable under the Constitution? Can we do stay-at-home orders? Can we shut down the courts? And that's probably an issue too big for us to handle today. Those are going to be issues I'm sure going to be asked more and more over the coming weeks and months. But for now, the Chief Justice is the last word, and we have to follow this direction. Of course, as things change, as new orders come out, and they will, we'll certainly be distributing that. Our firm will be sending it out. For Brownlee, Whitlow, Prate will be sending it out, and of course, all of the associations will as well. But that's essentially a statement of where we are right now. And for the federal changes that have come down the pipeline, I'm turning it back over to Chris.
All right. So in the, ooh, that was that was some feedback. Sorry, not sure where that came from. So in the midst of all of that, the federal government has been giving daily briefings, as I'm sure most of you are aware. And in one of the briefings last week, President Trump indicated that he and the director of HUD were in the midst of conversations that he felt were going to result in an order being issued by the director of HUD, which did in fact come out later that day. That's our fourth document that we want to take a look at real quick. Mr. Bell, there we go. So on the, waiting for it to load, late in the day, yeah, there you go. We can do it, come on.
It's loaded on my end, Chris. Do you not see it?
Yeah, it's just wonky on mine, but that's okay. As long as everybody else can see it, that's okay. There we go. It just took a minute. March 18th, last week, the director issued this memo for public release immediately that following the president's press conference that day. And it states as it's titled, HUD provides immediate relief for homeowners amid nationwide coronavirus response, suspending all foreclosures and evictions for the next 60 days. So the second that came out, everyone who read it started to really worry what was the context, what was the scope of that. And as you dig in, what you find is that the actual limitation is much more substantial than the title would have you believe. The director did not issue a nationwide moratorium on all evictions in all places, in all states, in all types, and in all kinds. What he did was say that for a certain category of properties, single family properties specifically, so anybody who's a multifamily operator immediately is no longer worried about this order. It doesn't apply to you. But for all of our friends who have single family properties, they are property managers or they are a national portfolio operator of single family properties, you're still having to parse through this. The then component of the order, if I blow it up a little bit here for myself, it says the order applies to all single family homeowners who have FHA insured mortgages for the next 60 days. So what that means is that you have to actually do some digging. If you are a property management firm and you help manage a rental property portfolio for single family rental property owners who are your clients, then you need to be making sure that you are finding out which ones of those people have an FHA insured mortgage for their property, because this order came out on March 16th. It applies for the next 60 days, which gets us to on or about May 17th. And that is in conjunction with the timing of the South Carolina Supreme Court's order. If the South Carolina Supreme Court's order allows May 1st to actually stand as the hopeful target date that we all saw, then come May 2nd, people may start filing evictions again. If the Supreme Court Chief Justice allows us to, well, that still leaves you 2 more weeks before this order is to be in further force and effect, even on its face, assuming it doesn't get renewed for any longer than 60 days. So in those intervening roughly 2 weeks, if you're in South Carolina and you represent someone who has a single family property, you need to know whether you're allowed to file an eviction case or not. Even assuming the South Carolina Supreme Court allows you to, you may still be prevented by operation of this order. And so a big piece of the puzzle is to be reaching out and making sure while you are in suspension, now is a good time to go do this research. Go reach out to all of your owners and ask them very pointedly that exact question. FHA insured mortgages, is it pretty easy to define category? Anybody who has a piece of property should know, and if they don't know, they can certainly easily find out by speaking to their mortgage company about whether they are or are not FHA insured. And if they are, then you need to make note of that and make sure that that particular property is in a different category of properties so that you can follow along with the HUD guidance. However long this order lasts, if it gets renewed for any additional period of time, you're going to have to be ready to honor that. If you are seeking to file an eviction on one of these properties, you are going to have to decline until this order or any extension of it runs out. And that's a big piece of the puzzle, because I know, representing a lot of single family properties here in North Carolina, we've had to send emails to our clients saying, listen, in North Carolina, you still have access to the courts. We can still file eviction cases, but we can't file them for you unless you have already done this homework, because this went into place last week. And so it's something that needs to be done. And just because the courts in South Carolina aren't accepting your cases right now doesn't mean that you shouldn't be doing the same homework and making sure you find out, because I think it's reasonable to anticipate that while May the 17th or 18th is our target date, it's certainly possible that the director might find that the impacts that led him to issue this order in the first place might not have run their course sufficiently by the middle of May, and he may want to provide some additional time, whether it's 2 more weeks till the end of May, whether it's a month, whether it's another 60 days, who knows? A lot of that remains to be seen. But regardless of what it is, we're hopeful that the state courts in South Carolina will at least reopen for business sometime much sooner than that. And if we're allowed to file cases, we need to be, all of you need to know for sure if you're allowed to file a particular kind of case based on the existence of this order. So
Chris,
keep that in mind. Yes.
sorry to interrupt. Can you clarify what this app applies to, please? I just had a question in the chat about where this, were you talking about just single family only when you're talking about the applicability, or were you talking about?
So,
sorry about that.
So if you scroll up to the top of the order, I'll let Michael scroll back up. There you go. All right. So if you scroll it, it's in the first paragraph, and it says the foreclosure and eviction moratorium applies to single family homeowners and only those that have FHA insured mortgages. So that's the category that you're looking for. So if you are whether you're a multi-state operator of single family portfolios, whether you're a local property management firm that represents mom and pop owners who ask you to manage their rental property for them, or everything in between, if you have a single family home and you have an FHA insured mortgage, this moratorium applies to you.
Thank you, sir.
And if you don't know, that's the investigation, that's the homework you have to go do while you have this automatic stay in place from the South Carolina courts. You've got until at least May 1st to be doing this homework and making sure you know the answers for each property that is a single family home that's under your management. Okay,
Thank you, sir.
And then yeah, absolutely. That's exactly the kind of question we want to get answered while we're on it. Thanks. The second document that came out is even more recent. This just came out 2 days ago on Monday the 23rd. FHFA, that is the umbrella agency, the Federal Housing Finance Agency, that is the parent company for Fannie Mae and Freddie Mac, which most of us know of as the large government property financing arms. And in this document, the FHFA put out a press release that says that they are now moving to provide a program that will provide eviction suspension relief for renters in multifamily properties. It's an interesting title because it sounds good, and I'm sure they wrote it that way so that it sounds good for the press. But what it really is actually is the opposite of that. It's not actually a renter benefit in its true sense. It is actually a multifamily property owner benefit that comes with a condition that you provide renters relief. So what the actual program goes on to say is that to help renters in multifamily properties remain in their homes, basically what they mean is that in order to help multifamily properties from going into foreclosure or default, resulting in multifamily apartment communities being foreclosed upon, and then the renters there being the victims, the innocent bystanders, the agency is going to support multifamily property owners during the coronavirus national emergency, and Fannie Mae and Freddie Mac, the enterprises, are going to offer multifamily property owners mortgage forbearance with the condition that they suspend eviction activity against their renters. So what does that mean? It's actually a program that they're putting out. FHFA is putting in place a program where a multifamily operator who has an FHFA loan or mortgage is allowed to reach out to them and ask for them to be included as a participant in this program. The ins and outs of the participation, the ins and outs of qualifying aren't addressed, and I'm sure are going to be a subject of further regulatory activity, probably not in the public view, probably done in direct contact with their clientele, not with the news media like this press release was. But what you're going to find is that the multifamily operators are going to have the opportunity to at least reach out and contemplate seeking a forbearance of their mortgage payments for the next 90 days. I did get confirmation yesterday that the maximum period of this forbearance is 90 days. It doesn't say that in here, but that is in fact one of the criteria that they've put in place for the program. So in theory, then, a multifamily owner could, if they have the right kind of mortgage, FHFA mortgage, could petition for forbearance from having to pay their monthly mortgage payment for the next 90 days. The government will allow them to repay that over some period of time, interest-free, but during that same window of time, the owner has to otherwise be current on their obligations with FHFA. They had to have been in good standing at the time they're making the request. So if the owner was already behind, they're not going to be allowed to get further behind. And they have to agree that during the period of the forbearance, when they don't have to pay their mortgage payment, they're not allowed to ask for an eviction against any renter who is unable to pay their rent as a result of the impact of coronavirus, is the language. They're suspending all evictions for renters who are unable to pay rent due to the impact of coronavirus. So that's a pretty big hurdle. It's a pretty big burden. And I think there's going to be a lot, as with most things, the devil is going to be in the details. But I do think that it's worth folks, again, doing a little bit of homework and finding out, does your community actually have an FHFA mortgage? If so, how does your community intend to handle that? What does your parent company plan to do? If they are planning on taking advantage of this, then again, the 90-day window of possible relief that could be provided to the multifamily community is hopefully going to be longer than the period of time that the South Carolina courts stay closed for business. So you need to know, as a homework item, again, what is our plan come May 1st if the Chief Justice allows us access to the courts again on May 1st? Are we going to be seeking new evictions? If so, who are we going to be seeking new evictions against? The piece of this puzzle that's important to note is that it doesn't apply to a complete eviction ban against all residents. So in other words, you can potentially be an owner that takes advantage of this program, gets forbearance on your mortgage payment in full, but still files eviction against people who weren't impacted by coronavirus. Lots of people on this call are still working their same jobs, getting their same paychecks. Many of us are renters ourselves. And there isn't any chance that I would be entitled to claim that I was a victim of coronavirus if my landlord didn't get their rent check on time. And the same is true for many of you. Many of you are not just property management professionals, but you're also tenants at other people's communities. And so the same would be true of you. You would be hard pressed to make a claim that you were impacted by coronavirus in any real sense. And so if you chose not to pay your bill, your landlord, even if they were getting forbearance under this new program, would still likely be able to file an eviction action against you, because there's no reason why you shouldn't pay your monthly rent because you didn't have an impact by coronavirus. So those are all issues that remain to be seen. How FHFA decides that they want to analyze that issue, what kind of proof they're going to require, what kinds of analysis the multifamily properties are going to have to do once they are in the program. All of those issues remain to be seen. They're things that we will probably be updating you on. I suspect that we're going to get some more press releases, or at least more release of information from FHFA on that topic too. And I'm sure that we'll have an update program where we share more info as it comes available. But those are the big things. Those are the two big federal actions that have taken place so far that need your attention and warrant some homework doing on your part, so that at least you're ready. And if and when the court releases us to begin filing cases back in South Carolina courts,
We've just lost Chris, I think.
Yeah, looks like it. So we'll give him some time to get back on. We'll go ahead and start some of the Q&A though, that Will hopefully can jump on board and answer as far as that goes. Just remember, guys, that again, we are recording this. It is going to be posted. It's going to be sent in an email to you guys, everyone who registered. It will be sent to your email address. And then again, Upper State Apartment Association, as well as Loebsack and Brownlee, have a YouTube channel, and it's going to be posted on that as well. So you can resource this. Down in the chat section, Michael has posted all the documents that we just went over. So you do have access that way if you want to go ahead and bring those up and save them to your computer. So further ado, so one of the questions that we have is that someone filed eviction prior to this stay, and they're wondering what's going to happen. Do they have to start all over again, or will it just start exactly where they already are in the process?
Yeah. Yeah, I've been reading through the questions, and it seems to be about half the questions is, do I have to refile if I already have a pending eviction? And the short answer is no. For this reason, the stay, pretend like it's a perfect freeze where it's frozen in time, where all the ensuing days that pass between the court's order of the 18th, 19th, staying any further action on the eviction, that's essentially what it did. It froze it in time. So if you already have a pending eviction, it's already been filed, it's already before the court, there's no requirement that you keep filing every month. Instead, if you've already submitted it, especially if you've submitted it through a law firm like ours, what we really need you to do is to continue updating us with fresh information as the accounts are updated. When you roll into April and you now are allowed of April rent, or there are April late fees, etc., merely update the ledgers with your attorney and keep them current. So as soon as the courts reopen for business, we're ready to use that information to move forward on your case. So again, pretend as if your filed eviction is frozen in time. There is no need to refile that eviction because the court hasn't even had a chance to hear the first one. And the amounts that are owed can be updated as we go in the court system. And as a matter of fact, not to bury you with too much in the way of statutes, but South Carolina code, there's a code called 27-40-790. It puts a duty on each resident that since the filing of a case, they have a duty to keep paying rent that comes due after the filing of the lawsuit. So they have a duty to keep paying that money. Granted, whether they do or not, it's another issue. But what that means is you don't have to rethink this and refile it every single month. Your case is still in the system. It is still pending. The Chief Justice did not dismiss all pending cases. He merely froze them in place. And I hope that answers a lot of your questions. That same freeze also applies to cases that have been fully heard and vetted. There's already been a hearing, or there's already been a writ/warrant issued with the court. Maybe the constable was holding it in their hand. Maybe they already served it. You're waiting for the set out. All of those were also frozen in time. And when the Chief Justice decides to unfreeze that, stay, issue a new order, lets everyone know, he'll define how those, at least I hope he defines, that those things will pick right back up in the order that they were at the time of the freeze. That is usually how most stays work. Granted, this is, sort of new territory for everybody. No one's ever seen a stay this broad or this large, but typically that is how a stay works. So no need to refile. But please, if you do have your cases with us in particular as a law firm, if you file through us, please keep updating your files, uploading new ledgers and amounts so we are up to date and can move that much more quickly to process your cases moving forward. By that same token, if you have submitted them through, and maybe I can let Chris speak to more of the mechanics of this, but if you have already submitted them to us through the nationwide system and it is sitting with us, but hasn't been filed because of this court's order and the freeze, we still have all of your information. Again, we just need you to keep updating it as we get into April or even May, so we know what the accrued balances are, so when the filing does happen, it will be that much more accurate.
That being said, with new evictions of people who do not pay, can they go ahead and send all the paperwork to the eviction team, even though we're not filing it with the court, so it's all in play just in case?
Absolutely. Absolutely. In fact, Chris can I speak to this too, but that actually assists us in processing the evictions faster when the court, when the stay order is finally unfrozen and dissolves. we'll be that much more prepared to file quickly because you would have already proactively sent us that information, allowed us to review it, process it, and error check it, and be ready to file. So yeah, instead of waiting until you hear about the courts unfreezing, you're actually doing yourself a disservice. Keep sending it and allowing us to have it in the system so it's ready to go.
Right, so it's faster to update, right? And that makes it way easier because if it rolls over to the next month, for instance, all you have to do is just get an updated ledger, right? Just so for your records. I mean, just that makes it quicker for you.
Yep. Yeah. At the end of the day, the easiest way to think of it is that our attorneys aren't allowed to go to court right now, so they have a whole lot of extra time that they don't usually have to devote to case review, and so everything you send them, all of our attorneys are able to sit down and analyze every one of your cases right now in real time and get it ready. And so as new people fall behind in the coming weeks, as we get to April now, when those people fall behind, if you haven't already submitted a case for those people, send those cases in. Our attorneys are literally just standing by, reviewing cases, getting them ready, talking to our clients to make sure we understand all the issues. And you're never going to have a time in the history of evictions where you're going to have more direct access to our attorneys than you do right now. Our attorneys are actively reaching out to all of our clients, talking to you about every one of your cases to make sure that everybody understands all the ins and outs, and so that the cases are literally as ready as they could possibly be, as if there was going to be a hearing on May 2nd. That's what our approach is for right now. And so yes, the more of the cases you send to us as they come to need processing, get them in and let us work on them so that they are all ready, and then we can make sure that your work is done as timely as possible as soon as the court lets us.
With the stay of execution of the eviction, what charges can we still charge as far as late filing fees and whatnot?
Well, the answer is still the same. In the intervening time periods, you can't charge anything unless you've been charged by us. So if you get an invoice from your lawyer for something, then it's something you could charge or ask your resident to pass along. If you don't have an invoice from your lawyer, then there's nothing to pass along. For sure, there's not going to be a single solitary filing fee paid to the courthouse because the courthouses aren't open for business. Whether you have an attorney's fee that somebody might be responsible for, that just depends on whether Thomas's firm or our firm have sent you an invoice for something. If they have, then you have that as a reason to ask the tenant to pay you back. If you don't have an invoice, then there's nothing to pass along.
Right.
Perfect.
Yeah, to piggyback on that, so the lease is in full force and effect. I've seen some concerns and questions about how the effectiveness of the lease, and then also to add to that, if the 5-day notice requirement, if somebody sends a 5-day notice, do they have to resend the 5-day notice before they can file?
Well, the short answer is no. You've already sent the 5-day notice. They're already, and for those of you who are already on the NAA lease, the National Apartment Association lease, the need to send a 5-day notice is already built in, it's hardwired into your lease. State code actually allows you to forbear even sending a 5-day notice. A lot of you using that lease merely send it because it's a courtesy. It's to let your clients know they're late or let them know about the late fee. But the short answer to your question is no, you don't have to keep sending them a notice unless you want to. I mean, if they're late for April, send them, follow your routine. Keep sending them those same letters. Stick to your routines, I think, would be the best advice. But no, you don't have to keep updating them just because of a court's order.
Thomas, this one might be more of a question for you. Someone was asking, I think more so about essential services. They're asking, how does it affect properties with work orders if maintenance cannot do them in case of a statewide stay-at-home lockdown goes into effect?
So you would still be able to perform the work orders more than likely because we're working to get, I believe the apartment industry and its employees are considered essential and exceptions to that. So they're still on site. Your maintenance team will be there. You just have to take extra precautions to make sure that you're not exposing yourself to the virus. A lot of our clients have sent out notices asking residents to be open with them. You can't require somebody to disclose. That's our main concern. For right now, I think Charleston County is about to issue a shelter in place. South Carolina, and just in general, we sent a letter to the governor, I think yesterday, and local associations, we've sent letters to mayors on behalf from the CAA. I think USAA was sending them out to all municipalities. essentially your maintenance team should be on site still. And I think what you need to do is make sure that you understand that there may be disruptions, limitations that you may not, if they need some help changing a light bulb or something simple like that, unless it's an actual emergency like a water leak, pipe burst, things of that nature, you may not get to them immediately. So there may be some delay due to the virus and the lockdown, stay in shelter order.
Someone else is asking if we have to offer a grace period to our residents to pay their past due balances before we can file eviction.
No, is a short answer. There's no requirement. Will a lot of companies, I suspect, consider that? Sure. But if you do offer such a period or such a workout or even a payment plan, and I may defer to Chris to discuss a bit more about fair housing on this issue, but for any companies that are thinking about walking down that particular road, please be mindful of the Fair Housing Act in terms of being consistent in how you offer these things. It can quickly become a fair housing swamp, a quicksand, if you begin doing case-by-case, workouts based on each person's unique circumstances. And there's going to be a lot. I mean, everybody's going to be in a slightly different position, and it's going to be very tempting to cut a deal for one group and another. Just remember your fair housing training and background. Consistency is key, and whatever approach your company wants to take, definitely do it. Ideally, by passing it up the chain so your entire company is on the same page and doing it the same way. And I'm going to pass it off to Chris because I know he'd like to comment on the fair housing aspect.
Yeah, Michelle, did I see a question come through about fair housing and late fees? I thought.
Yeah, it says, what would you recommend that our late notices state to ensure that we are meeting the criteria of the FHFA guideline for relief?
Oh, well, that's not going to be in the late notice at all. Late notices, just like Will said just a second ago, those are the same as they always are. Nothing needs to change about your late notice. And in fact, you probably should stay consistent so that there isn't any question of differential treatment of anyone.
Someone else asked if regarding a proof, they're asking, do you have any recommendations regarding whether we should ask for proof from residents who say they can't pay the rent due to COVID-19?
So that's going to be something that you're going to have to, under the federal order, the FHFA program, you're going to have to dig in with them and find out what kind of criteria they're going to put in place. There's no way to know right now. They do have a hotline that they listed. They have somebody who's a point of contact for the FHFA. And so those are going to be federally mandated criteria. I don't have any way of knowing that because I'm not an operator. And they haven't released it in any sort of press release that we've seen so far. I think you're going to have to make those phone calls yourself and find out what kind of obligation are you undertaking when you say I am willing to accept the obligation to cease evicting people who had an impact on COVID or from COVID, but what is the FHFA going to ask you to provide as proof that you've done so? The answer is I don't know. You're going to have to ask them whenever they put out their guidance on that side. On the fair housing side, there was a question that came in about fair housing and offering, I think, partial payment plans. Maybe that was the one I saw. And to the point of that question, the issue of offering partial payment plans is certainly one that there's little reason not to take partial payments from people in any state at this point. Whether you're required to do it a certain way like we are in North Carolina, or whether there's a much broader opportunity like there is in South Carolina, the fair housing implication is still the same, and that is you have to do it the same for everybody. You cannot have a program where you, for example, say, well, if someone asks for a payment plan, we'll let them have it, but everybody else we're just going to treat as normal. That's not okay. You can't have that kind of criteria. If you're going to offer partial payment plans or payment workout plans with people, you have to tell everyone that they have that opportunity. You can't just sit silent and offer it to a certain category of people, like the people who heard that there was one, and that would lead to abuses by your staff. Your staff are friends with people that live on your communities. Somehow, some way, people who live there would find out that there was a secret payment plan opportunity, and those people would get the opportunity to work out payments, but other people would not know about it and wouldn't, and they would claim discriminatory treatment. So if you're going to have that as an opportunity for your residents, you got to make sure that all the residents get the same opportunity. It cannot be done on a basis like that. It also probably can't be done on a basis of, did you get diagnosed as having COVID? That would be a HIPAA problem. Asking people to confirm they've received a medical diagnosis is prohibited under a different federal law. So you wouldn't be able to structure it that way either from a fair housing standpoint. And even if you could, it would be a fair housing problem because people who've been diagnosed with COVID have a disability, and treating them differently than other people would create a disability-related problem because you've created a category of people and excluded some and not others. And so there's any number of different parameters that could come into play there. All of them are bad. All of them create the opportunity for someone to claim discriminatory treatment. And so the easiest answer is, if you're going to have a payment plan, have a consistent one, generate a specific document. For those of you that haven't heard yet, NAA is working on creating a national add-on to their lease that will be a payment plan acceptance agreement of some kind. They're targeting having that rolled out by the end of this month, is what we're told. I wouldn't hold my breath on a specific date certain, but I bet you by the beginning of the first couple of days of April, you'll have something in your hands one way or the other that you could use. But those things are all part of the equation. Making sure that you have a clear understanding of things is the biggest part of the puzzle. Don't do things piecemeal.
And
We
if I
have a
could think,
couple people asking about partial payments on
Right.
people that have been evicted on, if it would stop the eviction process or if they would need to start all over again if they accepted partial payments.
no, the short answer is no, it would not stop the eviction process. Again, the statute I cited earlier, I guess a lot of numbers I'm throwing at you, but it's 27-40-790. It requires the residents to pay rent after the issuance of an eviction. But even then, under South Carolina law, put it this way, a number of viewers may be coming from other states, North Carolina, Georgia, what have you, where acceptance of a partial payment in some cases may be viewed as a big deal, as a waiver of your right to evict. But that doesn't really exist in South Carolina. You're allowed to evict even for, if they paid a partial month and there's just a partial month remaining. Now, I know a lot of the companies out there do have an across-the-board policy as a company. We just do not take partial payments ever. And of course, there's nothing wrong with that either. If you want to take that approach, you can. But taking a partial payment is not fatal to an eviction. Fair warning, I will say this. Local magistrates exercise a lot of discretion when it comes to that. Some of them are more biased when it comes to a partial payment. My best advice is to tell you this. A, does it impact your eviction under state law? No, it doesn't. You can take a partial payment. Two, if you've already submitted an eviction, you already filed, especially if you filed it through our firm, what would be a best policy if you do take a partial payment? Well, tell us, please. Send an updated ledger, number one. Number two, maybe send a quick email to us saying, by the way, we started accepting partial payments. If you start seeing ledger entries where we take, partial, that's why. We still want to proceed forward when the courts are unlocked. That way we have, a heads up of, why you took the money, what was the approach, what was the policy. And last, just to echo what Chris said, again, whatever partial payment policy you choose, please make it consistent. Do not pick and choose across the board. Otherwise, it is a fair housing issue, or could be.
I have another question about enforcement of the lease. Basically, the lease rights. Can the property manager issue a 14-day notice to disperse crowds of more than 3 or more than 4? I think the governor's ordered 3, no more than bigger gatherings than 3 in public areas as a lease violation, as far as violations under the paragraph 19 and 31 of the NAA lease.
I mean, sure. It could be a violation of those, but again, you'd be faced under the same freeze that you have, courtesy of
right.
the justice's order. You could file it. You could try to claim that. You could try to claim that it rose to the level of a crime. I mean, I think the governor classifies those now as a possible misdemeanor threat.
It's a criminal nuisance. Yeah, I think something along
right.
those lines. Yeah.
And you could try to qualify it, but then even then you'd have the issue of, is this harm to a person or property? We could argue it's harm to person because it encourages COVID, but again, that would be a novel argument to use in court as grounds to try to file an eviction. And even then, it's a sales job because the court made it optional. It's not mandatory that the courts take these type of cases. Your local magistrate may say, no, the door's still shut, I'm not going to take the case. So your results will vary. Could you send a letter telling them about the breach? Absolutely. It's your right as a landlord to notify your residents whenever they are in default. That's another example. The hope is that the letter alone will encourage good behavior, but then again, it may not. And if it doesn't, all you can do is contact your attorney, contact us, contact the courts. Let us help you walk through that, and then even more importantly, walk it to the court to see if they would take this case. If not, it still doesn't mean that your claim isn't valid. It is valid. It's just on ice for a while longer until the courts unfreeze and open the front door for new filings.
Yeah. The courtesy officers and police would probably be an option there as well, rather than a
Agreed.
notice. I mean, if you have one on site, I mean, it just help facilitate somewhat.
Absolutely, that's what they're there for. I mean, use your local police. If it's been mandated by the governor and it's a crime, by all means, call 911.
This might be for Chris. I've got a couple of questions in regards to forbearance. They want to know if they can still file, e-file if the owners decide to file for forbearance.
Well, so if they realize that they're qualifying under the FHFA program, then I think you're going to have to walk through that step by step and figure that out. We're probably going to be implementing a program ourselves where we ask our clients, do you have forbearance? Because whenever we get access to the courts again, it's pretty clear that this program is going to remain in place for some period of time, and up to 90 days of forbearance is optional. So there's going to be probably going to be a question that we're going to ask our clients at the time that filings start again, is did you take advantage of that program? And if so, is this person, has this person that you're filing on been vetted to find out if they meet the criteria or not? There's so many things, with it being brand new as of basically yesterday, there's so many questions that remain unanswered that we don't know today, but we'll probably know more next week. We're just going to have to keep a handle on this, but I think it's for sure going to be an issue that you're going to need at the property level to have some level of understanding about who you're filing on, and if you've taken the forbearance option from FHFA, you're going to have some obligation to make sure that the people you're submitting are in fact not people who would throw you out of compliance, because I'm pretty sure even if the court doesn't come down on you about that particular case, if it did and the FHFA found out about it and threw you out of the program, I'm pretty sure your company and the owners would be not very forgiving of a mistake like that. So I think it's going to be a lot of moving parts that we're going to learn more about as the days go on between this week, next week, the week after. But you're going to need to pay attention to that. You're going to need to make sure you're aware at the property level, are we in the forbearance program? And if so, what does that mean? How do we have to change our interactions with our eviction filing practices, even once the courts allow us back in?
We've had a few people ask the same question, wanting to know if they're not allowed to ask about with HIPAA for COVID positive, but they're wanting to know if they do know that it's positive, how can they relay that to their team members?
That one's one I think that a bunch of us have decided that NAA is really taking the lead on that, and they've put out a bunch of guidance here lately. They've had webinars and seminar materials and those things. I think your best guidance is going to come from them on questions like that. If you haven't, I know that all the affiliates here have seen, and I'm sure most everybody on the webinar has received the same almost daily email from NAA that I have that relate to those materials. I would use those as your guidepost. NAA is spending so much time and energy putting those things together that I think they're going to be your best, most consistent resource for best practices recommendations, whether it's communications with your staff, whether it's communications with residents, whether it's communications with outsiders. I would use them as the guidepost there. Recognize that it's a touchy subject, recognize that there's a need for consistency, and rather than try and replicate what NAA is already doing. I think I would just tell folks to go there and do the digging because they're really, really, really invested in this.
Another good question that just came through was, are we able to give a non-renewal during this time?
Fair housing.
Yes.
No, you shouldn't give non-renewals in the first place. The advice I give every seminar I teach on the topic of fair housing is that if you're still non-renewing people in this day and age, you are woefully behind the times. Non-renewals are not a tool. Non-renewals are not an objective. They are not a way to get rid of residents you don't like, because you're singling those residents out for specific, unique treatment with regard to their lease. It's virtually a definitional discriminatory act. Non-renewals should only be used in the case that you have a company policy that says, in the event that one of these 4 things happens during the term of your lease, you will not be offered a renewal. Unless and until your company has a plan that looks or sounds like that, you shouldn't be non-renewing anybody unless Thomas has specifically reviewed it and told you it's okay, because it is almost not ever going to be okay in the absence of a plan like that. Federal Fair Housing Act says you cannot take an adverse action with regard to person's either application or lease unless it is a completely non-discriminatory purpose, and non-renewals are not done on any sort of regular basis. And so that makes them, anytime you choose one, you are at risk of a fair housing violation. And I've defended that claim so many times that I just have taken it upon myself to make this my mission, to rid the non-renewal from the universe unless and until it is done in a way that Thomas has reviewed and can bless for you. Non-renewals are always a bad idea.
If I can piggyback on that, the short answer to the question is, can you? Yeah, you can. Should you? Probably not, unless your company has a defined list of reasons to non-renew that you follow religiously. That's the short answer. And if I may, because I know that time is growing very short, but it seems to be a repeated question I've been seeing flow up and up, and I'm not sure if we were ever clear. You know, can you charge late fees moving forward? Can you charge any other fees for any other minor violations of the lease? And the short answer is the courts didn't, or the governor didn't say thou shalt not enforce your lease. No one has said that. You have every right to pass on a late fee to someone who has not paid pursuant to your lease. End of story. If someone else is violating another portion of the lease that involves fines or fees that you can pass on, you know, for a variety of things, litter, failure to clean up after your pet, things of that nature. Can you pass on those fees? Sure you can. If your lease permits it and that's part of your normal course of business, yes. But again, the same prohibitions apply. It doesn't matter what the breach is, how bad it is, how slight it is. Again, you won't get relief in the courts, at least for the foreseeable future, until the Chief Justice dissolves his order. But can you keep charging the clients, billing the clients for breaches? Yes, that's the short answer.
So to piggyback that, we've got someone whose their company has already waived, told them to waive April late fees. They're wondering if this goes into May, if now with fair housing, do they have to waive May's as well?
I'd kick it over to Thomas and Chris, but my gut shot is, well, no, you can make a company decision time-based. You can say, hey, company-wide, we've waived late fees for April, congratulations. However, we will not do this in May. As long as you give everybody notice and you're applying that consistently, I think it's permissible. However, I want to kick it over to the other gentleman to flush it out a bit more.
Yeah, as long as it's like a one-time courtesy, as long as it applies to everybody, I think you're doing this in a very difficult time for everybody, and I think it shows good faith. But there's also a non-waiver provision in most of the form leases that just because you don't enforce it 1 month doesn't mean that it's not going to happen again. There's extenuating circumstances here and you're applying it to your entire property wide, which actually kind of hopefully will encourage them to pay rent, even if it is late. Because right now you can enforce your lease, you can send your letters. You lost a little bit of teeth, but it's only temporary as far as your eviction. Your weapon is not there if that's a last resort in any case, but it's only a temporary thing. And I think I've had some companies I've had to write letters for where they basically, some of the residents are treating it like martial law. Like there's no, you can just go, it's a free for all. Well, that free for all has a time stamp on it at some point. The judge is going to drop the gavel one more time and sign and pen to paper, and then they're going to regret those decisions, and you still have to, it's business as usual. And there, I know that's until further notice, and that's how I look at it.
Another question that's came in now is if the if the put outs already happened prior to the stay of execution, or they moved out voluntarily, still owing a balance, can they send them to collections?
I don't see why they couldn't. The liability stays the same. The courts haven't shut that down. So whatever your routine practices are for that, you could still send them to collections if you wanted to, if that's what you normally do for all of your charge-offs and your post set-outs.
Agreed. Yeah, the circuit courts are still accepting filings, so you can. I mean, they're still having motion hearings, non-jury trials, things like that. If you want to go get a judgment, you just can't file evictions right now in foreclosures. Those actions are the two exceptions until further notice.
Can a maintenance person request a resident to move to a different room while they're completing the work order?
I think it's pretty obvious for everybody that the federal government's made it clear that at every state level there's a 6-foot window. Now, moving to a different room, I don't know that that's something I would want to parse out specifically, but maintaining a 6-foot halo is pretty universally mandated. So I think that's easy. But how you preserve the 6-foot halo is probably you got to be. I think you need to be sensitive to people and residents' needs in particular, but realistically speaking, yeah, it's pretty easy to say I need you to keep your distance, but trying to direct them as to where you want them to go, I think that might be pushing the boundary a little bit.
We want to be respectful of everybody's time. I know some of you, we didn't get to your questions yet. It is just a little after 2 o'clock. If the attorneys don't have another appointment and they want to hang around for 5 or 10 more minutes, I do know that I can save all of the unanswered questions and we can try to get back to you. But I'm going to leave that up to Chris, Will, and Thomas. I don't know what their schedule is like the rest of the afternoon.
Yeah, if we can cut off the new questions, Tom, I've got 5 minutes. We can bang out a couple more
Absolutely.
Of the ones that are already in there. If everybody else does, that's fine. Just everybody.
It seems like
let's just not take new ones.
We've got a few that keep on going back to the non-renewals and the move out. So we got someone asking if they're on a month-to-month lease, if they can give a 30-day notice. If they issued a non-renewal to be out by April 30th and they gave them 60 days, do they need to halt that? Non-renewing people because they want to renovate their unit. So that's 3 questions that all go to non-renewals.
Yeah, I think those are all easier enough to send to Thomas and his colleagues at the firm and let them answer those specifically. Those are pretty fact-specific inquiries, not generally COVID related inquiries. But the truth of it is until the courts are open for business, anybody you sent a vacate notice to, doesn't matter what date is, there isn't anything you can do other than get the case ready. If the move out date was supposed to be April 15th and they don't move out on April 15th, then submit the case and let's get it prepared. But if you're wondering whether you should give them more time or give them an opportunity for an extension, that's a fact-specific one. You would want to reach out to Thomas offline and ask him specifically to walk through it with you.
Right.
So if residents asked to break their lease due to job layoffs from COVID-19, are we still able to charge them the buyout fees and require a 60-day notice to vacate?
You're permitted to do it. South Carolina has a specific code that allows you to charge a reasonable, termination fee. Generally, that is viewed as no more than 1 month. You can do that. That's actually hardwired into paragraph 11 of the South Carolina version of the NAA lease. So short answer is yes. Trickier answer, will they pay? That's going to be the big one. But sure you can. As long as your approach is consistent in how you handle it.
Is it best for properties to notify residents of payment arrangements for April, May rent before the first comes?
That's a judgment call,
well,
right?
It depends on what it depends on what the question means, but yeah.
I would prefer a wait and see approach to see how many people actually pay. or how many people hold off and then send out a notice to, and they may come to you. I mean, you could send out a notice. If you send out a notice now that you're offering payment plans, you may get everybody in the entire community that defers. I mean, that's the risk. I mean, or a substantial amount just decide, yeah, I could use a couple extra bucks this month. You know,
Yeah.
I mean,
I was just having a discussion with a colleague of mine just yesterday, and we were texting each other, and we were asking, you know, are these sorts of arrangements self-fulfilling prophecies? And I guess we're all going to find out. Your results will vary.
So someone wanted to know if an email confirmation would be accepted as a signature for a promise to pay.
Kick it to Thomas.
No. I would say I wanted something in writing, like it's got to be DocuSign or something like that, because just me sending an email saying I accept, it gives you grounds for an argument, but it's going to be more trouble than it's worth if you don't get a wet paper signature or DocuSign, something along those lines, something other than an email, because it's not really a signature at that point. Yeah. Unless so it just creates more issues than it may be worth at that particular time.
Another question was if they've already started to work with the resident in regards to payment and figuring out what to go on. Is there any best practice to be used so that the court doesn't kick it out when, if they do end up having to file eviction against them?
That's probably a fact-specific question too. I mean, in terms of how it plays when it gets to the court or a magistrate for an eviction case, it all depends on what the outlines of that agreement was. Did that agreement contain provisions that made it a breach of the lease if they failed to pay by a certain time frame? If so, maybe, but that's very fact-specific. It depends on what that custom agreement says. And I think for that, you'd want to kick it to Thomas first, explore that with him to see if that is a valid type of contract, because there's going to be a lot of homemade contracts that are floating around out there, and I can't even begin to speak on how enforceable they are or how they'll be treated by a court, unfortunately. It all depends on what those agreements say, which is why I think we all recommend you approach an attorney like Thomas, Brownlee, Whitlow, Prate, to review any such agreements like that to make sure they're legally enforceable when and if you have to in an eviction court.
All right, well, I got a couple more. If properties are still showing, can we ask questions about sickness, and can we deny a tour to someone that has self-identified as being told to self-quarantine?
Oh, fair housing.
That's another one I would kick to the NAA side. I mean, that's an NAA question, and they're working hard and heavy on those.
Yeah, we have some recommendations, but there's nothing foolproof at this point. I mean, it's just throwing darts at a dartboard on some of this stuff because it's so new. It really is. It
all boils down to, is COVID a disability?
And the answer is we don't know.
We don't know.
It's a gray area because it affects everybody differently. Does it arise to that point? And I've had some properties switch to virtual tours if you have that capability. But then if somebody is visually impaired, then you have to be prepared to be able to communicate and accurately describe via phone call what the apartment in general to them. They just be willing to make those concessions, those accommodations at that point. I mean, it's because there are concerns about having on-site visits, because the way I look at it, you approach it as everybody has it. You look at everybody, the person next to you has it, act accordingly, conduct yourself accordingly.
Yeah. That's more of a fair housing question than it is an eviction related question. I mean, my understanding of fair housing in terms of disease versus disability is that if it's a finite disease that has a finite time period of cure, it's not considered a disability. But if there is going to be a test case, it's going to be COVID-19.
Yeah.
So we couldn't even begin. I imagine the three of us, we couldn't even begin to touch that with any degree of certainty.
Mm-mm.
I think this was going more towards the HUD stuff. It says, will payments be added to the end of the loan or another avenue? I'm not quite sure.
The FHFA program. Yeah, That's the FHFA. The obligation is there's an obligation to repay whatever you forbear. It's not a forgiveness program. It's a repayment obligation. I've heard that they're planning on making the repayment happen in 12 months, but I don't have any confirmation of that yet.
And is there anything out there from the insurance companies in regards to filing loss of rents?
Thomas?
Not that I'm aware of yet.
I think you're going to have to prove that you have loss of rent first.
Right. Yeah, exactly. We're not, I mean, yeah, you probably you'd have to show this related to this after the state of emergency has been declared. Absolutely. So right now, I don't think you can show any losses until April 1 to see what kind of impact it has. And then we can start that discussion probably is the best course. How many late payments do we have? How much lost rent? Because people may eventually pay, or they may enter into a payment arrangement, things of that nature. There's so many unknowns at this point. Still.
Yeah, not to get too deep in the insurance weeds, but a lot of insurance policies exempt pandemic specifically. So your results will vary.
Right.
All right, thank you. And last but certainly not least, in regards to the payment plans, if a company decides to roll one out, do they have to publicize it to the whole community, or can they wait until somebody comes in and lets them know that they're having issues?
I think I said that already.
Yeah,
you cannot
yeah.
wait and see. If you're going to have a payment plan option, you have to tell everybody, because if you took a wait and see approach and offered it to the people who asked, then every one of the lawyers on this call knows that every one of our clients has an example of a property manager, assistant manager, or maintenance staff person who is friends with 3, 4, or 5 of the residents of the community, and they would for sure tell them that we will offer you a payment plan if you ask. And that would create a discriminatory problem immediately. So there's no way to do that without knowing for sure that it would be used poorly by the people that work there. There's no way to convince me or anybody else that your staff of people wouldn't do that.
Right. Yeah. To clarify my point earlier, I just want to say that I was saying wait and see. The wait and see approach as to sending out a notice to notify everybody that you're offering. The key is you're offering it to everybody. But you got to, whether you do it before or after is a judgment call that you're going to have to go through with your owners and your higher ups just to see what they want to do at that point, because it's a timing thing. If you do it up front, you run the risk of everybody entering into that payment plan. You get nothing for 2 months, and then there is. I mean, I'm anticipating hopefully it'll be a month or two, and then we'll be back on course and everything will iron itself out. But there's no guarantees. The timing of it is. If you wait and see, you may just get nothing in April, and then they'll just say, well, I'll figure it out by May, and you just can evict me then, because I know you can't touch me right now. So
yeah, it's not, to Thomas's point, it's not whether you can offer a payment plan, it's when you decide that you are going to offer, and you have to make it equally available.
So we want to thank everyone for hopping on. Also remind everybody that this was recorded. It is going to be emailed out to you. It also will be on the Upper State Apartment Association, as well as Loebsack and Brownlee's YouTube pages. Also with the Upper State Apartment Association, they do have the NAA resources already uploaded on there. You can also go to the National Apartment Association at naahq.org to access any of the NA information as well. Thank you guys again for hopping on this call, and stay well out there.
Thank y'all.
Thanks, everybody.